while it just registers. Julie and Mark, could you please turn your cameras off? And if we could put a little note in the chat of who you are, where you're from, and how close you are to needing to work with an inspector. That would be helpful to us.
Okay, Marge, thanks.
Okay, we're dismissed.
Okay.
We're done. Yeah.
Up and running. Brilliant. Well, good afternoon, everybody, and thank you to so many of you for coming along today to this webinar with the Community Planning Alliance to meet a planning inspector. And the planning inspector we have today with us is Rebecca Phillips. So thank you very much for giving up your time to talk to us. And it's a really important session, this one, because for most community groups, the Planning Inspectorate is kind of, well, it's obviously very important because it's the ultimate arbiter after long campaigns in many cases. And it's also potentially a bit mythical because if you haven't ever been involved in planning before, then you don't know what to expect, how to present your evidence, or what you should be doing. So yes, it's a really important session. So we're very lucky to have Rebecca from the Planning Inspectorate. She's got over 12 years experience as a planning inspector. She's been the professional lead for planning appeals at the Planning Inspectorate for over 3 years. Rebecca is qualified in town and country planning and marketing, and then there's a very long list following here, and has a background in economic development, regeneration, development finance, strategic marketing management and policy development. So a really good suite of sort of tools to help you making your decisions, it sounds. Rebecca's also the Royal Town Planning Institute representative and chair of the RTPI Joint Distance Learning Consortium Board. So a wealth of experience there. So what we're going to do today is first I'm going to share my screen and show you some slides. We're not going to bore you to death with slides, but we're going to talk through 4 topics. Now, what happened was that when about a week ago, I put a question onto Facebook saying what questions might you have for the planning inspector, and I think I had about 100 comments. So I've boiled those down into a series of topics for today that Rebecca's agreed to talk through, and she's also very kindly agreed that we might well need a second session because I've got pages and pages of extra questions that I couldn't quite fit into today. So we're going to talk about the Planning Inspectorate itself, how community groups can interact with the Planning Inspectorate, how PINS interacts in the planning system, as in, is it just enforcing or is it influencing back to government? And then a few technical points at the end. So we're going to do each section one after the other. I will set the scene, and then Rebecca's been given a few questions to talk generally about. If you have questions throughout, please can you put them in the chat, and Marge and Caroline will monitor those, and we'll do those at the end of all 4 of the sessions. So we're going to start by hearing about the Planning Inspectorate, but the first thing when I hand over to Rebecca, the first thing I'd like her to answer is, did she always want to be a planning inspectorate when she was a child? And then more generally, there's a lot of misunderstanding, I think, about what the Planning Inspectorate is for. So it'd be great to understand the purpose. Things like what qualifications planning inspectors require, what kind of training you get at the beginning and ongoing, and the more technical parts of the job, such as viability, biodiversity, net gain. Are you allowed to get in help for that, or are you expected to be a jack of all trades? And then there's been a lot of questions around consistency in decision making and how you do your quality checks, and kind of you've got a series of inspectors all over the country operating on their own. So how do you manage that? It's quite difficult, which led also to sometimes we seem to see 2 inspectors rather than 1, which strikes me as a very good idea because you have a lot of responsibility on your shoulders as one inspector on your own. So do you think that's a good idea? Is that a trend? And should we be seeing more of that? So that's the kind of the general outlook of the Planning Inspectorate. I will now hand over to Rebecca for this section. Thank you.
Just before you start, Rebecca, sorry, could we ask everybody who's not a speaker to turn the cameras off? Some people are struggling with bandwidth, so if you're not a speaker, please do turn your cameras off. Look for the little icon that looks like a video camera and click on that. We are recording this session for those who have recently joined. Okay, thank you. Sorry, Rebecca.
No problem, and thank you for that introduction, and thank you for inviting me. And clearly there's a lot of interest in this afternoon's webinar. I will have to start by saying I can't talk about individual campaigns or you know, appeals or events or anything of that nature, clearly, but what I'd like to do is really explain the role of the Planning Inspectorate, you know, give you a little bit of an understanding about our background and what we are looking for when we're running events, whether it's appeals or examinations, what helps us then, if you like, what we need to hear from you, and the sorts of things that help us in running an efficient and a smooth event, which will help you as well. And just to answer any questions that I can, albeit, as I said, I can't answer anything on specific cases, you know, or anything like that, but hopefully you'll come away with a better understanding of what we do and some of the challenges that we face in running an event as well. So Rosie set the scene. She asked me if I would always wanted to be a planning inspector. Well, it's not. Planning is something I'd always had an interest in as a child, simply because it, you know, it affects everything that you do. And I before this role as a planning inspector, I worked for the Royal Town Planning Institute and was, you know, clearly very, very interested in planning from a young age. I think that, you know, the purpose of the Planning Inspectorate, well, you know, you're probably aware that we deal with planning appeals, enforcement appeals, we deal with local plan examinations, national infrastructure project examinations, and we deal with other areas too. We call it a specialist casework, but it's everything from common land to rights of way, high hedges appeals, tree preservation orders, and some of the environmental permitting cases that we deal with as well. So quite a lot there that we cover, but probably most of you will be more familiar with our events, either you know, from Section 78 appeals through inquiry or informal hearings, or perhaps through the local plan examination process where our inspectors run examinations as well. In terms of qualifications, well, as Rosie outlined, I'm a planner by background myself, but we tend to draw on a wide pool of professions as inspectors, and that could include architects, engineers, planning lawyers, or anyone from an environmental background as well. They tend to be the sorts of professional background that would come in as a planning inspector. Our training is intensive. We bring in inspectors for an initial 2 weeks of residential training to understand the role of an inspector. And then we build on that. So we start inspectors out with, you know, the basics in terms of policy, legislation, and the sorts of things that they'll encompass. And then we build on that to develop their knowledge and experience in areas that are a little bit more difficult, like greenbelt and, you know, sort of those sorts of areas, conditions, and that. Then once they've successfully completed the training and undertaken a variety of written representations, that sort of site visits on a number of those types of cases, then they'll do a hearings training, which is understanding then how to run an informal roundtable hearing, and then build on that then to run a full-blown inquiry, and they'll get training in that and run some of those. In terms of specialist training, then once they've reached that level, they may go into local plan examinations, and we'll do a special bespoke training programme for them. And again, they will get an opportunity to run a local plan. And of course, NSIP, then the National Significant Infrastructure Projects, is another area where they may specialise and become a panel examiner, for example, and examine those. So we're constantly building and evolving on that training. In addition to that, we do specialist training. So of course, we'll train inspectors to do heritage work. They may do renewable energy work, wind farms, solar panels, etc. Retail is another specialism, minerals and waste. So there's a plethora of specialist training that we run as well, and we run intensive training throughout the year to make sure that our inspectors are equipped and have their continual professional development up to date too. So it's really important that we continue with that investment in our inspectors, and they're equipped to deal with the job. Now, on the technical aspects, we have a number of inspectors that are specialists in heritage work or biodiversity and environmental specialisms, but we're not all specialists and experts in everything. So, you know, for you to build an understanding of some of the challenges that we face, that we deal with a plethora of technical evidence, and we're not always technical experts in that particular area. We have a very good thorough grounding in all of those areas, viability, environmental areas and others, but some of our inspectors will specialise in those areas and conduct casework at the highest complex level, where they've really honed that specialism, and there'll be steps for them to graduate towards that. So we won't throw an inspector into a very complex case on, for example, heritage, until they've done the training and gone through different levels of competency on that, for example. But we do have to deal with a lot of technical evidence on a wide range and variety of topics, as you can imagine, as an inspector. So we're constantly building on that training and learning with them. The two inspectors will sometimes, there is a need where we feel that it would be easier to have, or better for the more efficient running of an event, to have more than one inspector appointed. There will always be a lead inspector, and then there will be an assistant inspector helping them to run certain elements. So, for example, some of the recent areas where we've had a panel of inspectors at Stansted Airport, proposal for another runway, and Bristol Airport as well. Clearly, that the appeals of that magnitude are very wide-ranging and complex and lengthy. So we found it beneficial to have more than one inspector appointed to deal with that, and they will deal with different discrete topics within that range as part of that inquiry.
Okay.
So hopefully that covers the questions on the first bullet.
Yes, no, that's perfect. Thank you very much. It's interesting, isn't it? Because the local plans that I was involved in were horrendously technical and complicated, and lots of political pressure. And I did feel for the one inspector sitting there having to deal with all of that. So it's interesting that how much you actually have to try and understand and know in your role. Okay, so the next section is how we as community groups should best interact with the Planning Inspectorate. So there's some questions around the resources and support that are available to community groups, and I think in support, if you could maybe talk about the programme officers as well. Then how best we should present evidence in writing or in person when we're at a hearing, whether there are any sort of do's and don'ts or horror stories, and whether there's a difference between how we should do things at either sort of Reg 19 stage before plan submission, hearing statements, at appeal, or at an NSIP inquiry. And then, do we need to get a barrister? People are always asking that, or are we fine to turn up at an appeal without one? And finally, would you prefer to have submissions from, say, 1,000 supporters individually, or would you prefer community groups to coordinate them all and send them in as a batch? And does one or the other carry more weight to you? So yeah, really general talk about how we should be best interacting so that we can make our case effectively in the same way as the professionals in the room will be. Thank you.
Okay, thanks, Rosie. I'll break that down because I can see somebody's asked about what Reg 19 is for a start. So I'll break that down into local plan examinations and larger appeals. Okay. So the resources available now, that very much depends on what type of event it is. Now, if I could start with a local plan examination first, that tends to be well resourced with an independent programme officer that's appointed by the council, not necessarily an employee of the council. They're appointed by the council, but they work completely independently for the inspector. So they're sort of the go-between, because it's really, really important that an inspector's impartiality is upheld. And clearly the inspector cannot have any dialogue with any one party other than in public, so that everyone can see what is being presented to him or her, and there is an equal opportunity for everyone to be involved, and everything is transparent and open. So the role of the programme officer is key, and Regulation 19 is the point in the regulations for local plan examinations where public participation needs to be made. So, for example, in a local plan examination, unless the public, whether that be community groups or individuals, engage with the process at that Regulation 19 stage, when the council goes out and asks for, goes out to consultation on its draft plan, unless they've actually engaged in that stage, then it's very difficult to get their involvement later on. There are certain rules and procedures around local plan examinations that are different to other appeals. So it's really, really important that if you want to have a say in the local plan, then you do that at that Regulation 19 stage. So that's hopefully answering that question that came up. In terms of resources available, well, the programme officer is really, really key to that in a local plan examination. Now, in some of the larger, more contentious, long-running inquiries, the councils will appoint an independent programme officer to help manage that, and that's really, really helpful to an inspector, because that helps then with maybe even running like they do in local plan examinations, a website whereby all the examination material is then hosted on that website for the local authority, and everyone has easier access to it. Now, easy access to documentation should happen anyway, but I think with the programme officer there, it's much easier for the inspector and for other groups to engage and go through that programme officer, who will help guide them through the process as well to some degree. In terms of asking whether you need a barrister, then no, not necessarily, but there are, just for you to know, we work closely with the Planning Environmental Bar Association in terms of developing protocols, as we do with other stakeholders as well. And I know one of the things that we've asked them is whether there are any opportunities for barristers to do work on a pro bono rate, which they do actually, they do that. And that's, if you look at our guidance, on our procedural guidance, there is actual information on that. So, for example, they've got planning aid in England that they do work for, and you can actually approach them for help, or, look at that list of pro bono barristers who will help do that. And the reason that can be sometimes helpful, you asked a question whether we, as inspectors, we want, individual 2,000 representations or community groups getting together as one voice, then clearly that is very, very helpful to us. It cuts down the amount of time that we have to read, and often the representations that we read on an issue can be repetitious, for example. So it's really, really helpful, and insightful if community groups can get together with one voice. It doesn't mean that their voice won't carry less, won't carry as much weight. Just because you say something 2,000 times and it's the same thing, that won't carry more weight just because more people are saying it. What we'd like to hear is that point well made, but by ideally one person on behalf of an organisation. Now, that's not to say we would stop stop anyone from submitting a petition if they wanted to. But it's a waste of inquiry time. It's a waste of inspectors' time reading the same sort of thing a lot of times. And as inspectors, we set out our main issues, where we're reading what we can see as the main issues between the local authority, why they might have turned something down, as well as reading all the representations as what we see as the main issues. And usually an inspector at an appeal will set out the main issues at that event, or maybe a pre-event, the case management conference ahead of that, and say, look, I see from my point of view, this is the main issue. So these are the main issues that I set out and upon which my decision will turn. And, I think that's really important that you understand that those are the main issues. They're not the only issues, but they are the main issues as the inspector sees them, and they've narrowed it to that point. And that is for the decision maker, the inspector, to determine those main issues. So I think it's important, if you're making representations, to bear that in mind and to focus, as I say, on what you think are the key issues that are going to be important for the inspector to hear and understand from your point of view.
Okay. Brilliant. So what would we do if there were an issue that we felt was extremely important that hadn't come out in your main issues as an inspector, for example?
Well, I don't think it'd be unusual for anything to come as a surprise to inspector. If the inspector's read all the submissions made in the representations, then nothing would come as a surprise. And clearly, through the course of an inquiry, there would be an opportunity to have your say about certain matters, which are important. The inspector will take them into consideration. But I think for the inspector, I mean, some of the things that are really important for inspectors are really, you know, having those helpful outcomes. So you asked about horror stories, and you know, I led many an inquiry, and things like you know, many participants turning up and observers. I once, you know, ran an inquiry. It was a McDonald's a proposal, and you know, very cleverly actually, the residents had got together, and when I went on site, I could see all in their windows you know, the usual air march, and no, we're not loving it, and you know, things like that. It was a very clever way of doing it. But what I had to do was, before that event, in the big council chambers, I had to you know, sort of stop sort of all the residents, and there were many of them, and I wanted them to hear and participate in the inquiry. It was running for a week or so, but they'd turned up with placards and everything. So I knew the strength of feeling. I knew feelings were running high, and I knew that there was a lot of objections to it. But of course, what I couldn't do is possibly allow those placards into the room and for people to start protesting in that way, because of course, you know, that's not going to help me hear the evidence and get to what I need to go away and write a decision. What I need is actually people there to engage, you know, with it. And I've got a duty as an inspector running an event to make sure nobody feels intimidated, and everybody gets their fair share, you know, and fair opportunity to put their point across. Nobody feels intimidated. I don't allow clapping and jeering or geeing people on or booing or hissing, or, you know, any of that could be seen as quite intimidating to some people, and I've got a duty as care of to those people, as well as making sure that everybody feels comfortable with putting their points across without fear or favour.
Yeah, that's interesting, isn't it? Because it's not at all like a council chamber, for example. And I think maybe all the people that have gone through their campaigns for years, they've got used to, I mean, you're not supposed to jeer in a council chamber, obviously, but it's very much a sort of technical legal process, isn't it, that you need to go through. So I think that's probably important to remember. I think the other thing that I took from ours is that the inspector, even if there were things he appeared not to be raising or talking about, he kept reminding us time and time again that he had read everything, and we had to assume he'd taken it on board. Even, and if he wasn't questioning, it didn't mean that he didn't care. It just meant he'd already got enough information. So that was quite helpful. A little detail one here. Do you expect people to call you ma'am, or the male one sir? We had a lot of sir at this, with great respect.
Yeah, and that's the usual convention. So, you know, in the early days when I started as an inspector, there were much less of a sort of female inspectors, and I found myself being called sir a lot of the time, and that's even by the female barristers, by the way. They got so things.
Yeah, instinctive.
Puddle, what to call it. You know, and I'm not hung up. I know that with inquiries there is a certain amount of formality in it, and if it's easier to call it sir or ma'am, then so be it. But I'm equally happy with Miss Phillips or Inspector, or I've often been called Madam Chairwoman, and you know, people just get confused, and I'm more than happy to put people at ease and say, don't worry about what you call me. It's just there is a certain amount of formality in it, but you know, we wouldn't want people to lax into too much informality, because then that would make it harder to run it, you know, effectively, and make sure that everybody was sort of abiding by the rules, and we can hear the evidence. But that's it for us. It's about hearing the evidence. So, you know, you might find that an inspector might say, you know, interrupt and say, excuse me, you know, I've heard this, I want to focus on that. And that's just really about, you know, making the use of the time. It doesn't mean that they haven't considered or won't consider the point. It's that they want to, you know, focus the discussion, because there's usually a lot to get through, you know, even with inquiries that run for weeks, and they want to focus the issue on the key points, and maybe, you know, make sure that they understand what your points are. And I think that's for inspectors, it's really, you know, two things really. They're continually looking for resolution and common ground, and that's not just between the main parties. So often you might hear an inspector asking for a statement of common ground, and it's really important to have that up front and early on, so that the two main parties, that's the appellant and the local authority, can narrow the issues upon which they are not in agreement. And I think that's really, really helpful for inspectors to have that. And I think also constructive discussions between we look for that. We look for constructive discussions that have been held between, if a group are objecting to a proposal, we'd like to see that there's been constructive discussions between, say, the developer or the promoter of that scheme and the residents, and proper community engagement. We, similarly in a local plan examination, we're looking for there have been, proper community engagement to have helped hopefully narrowed the issues, so that we're focused on the real issues of tension and non-agreement between you. So we're drilling down really the essence of the disputes, or disputes, depending how many there are. What's the real substance of the issue in contention? What form does it take? What are the respective positions? And hence that'll inform our questions throughout. Really, we're just looking to narrow down the issues, finding out exactly what it is, which is the nub of the disagreement between either the two main parties or one of the main parties, and either supporters of the scheme or objectors to the scheme. And what they are, so that anything that you can do to help inform that is really, really helpful, which is why you might find that inspectors will stop what they call repetitious discussions on the point, because they'll not say, I've heard that and I'm really trying to do my job and drilling down and focusing what the real issues are. Yeah.
Okay, no, well that's music to my ears, the whole focus on community engagement, which, as we know, often doesn't happen the way it should do. And also extremely helpful. I bet lots of people are Googling while they're listening your reference to the Pro Bono Planning Environment Bar Association. So that's really useful to know. That site's probably going to crash in a minute, I expect. So thank you. So are you done on community groups and the inspectorate?
Yeah, I think so. As I say, it's about really narrowing that down. If you can get a spokesperson and or even a few spokesperson on different elements, if you've narrowed the issues down, that's perfectly acceptable. But it's much easier for an inspector to understand the issues than to have everybody in an inquiry room all talking about different things, and the inspector has to manage that, drill down the issues and run the event, and it's quite a challenging task actually. And what we want to do is make sure everybody has a fair opportunity to participate and get their points across. But what we're looking to do is having the points we want, is all related to narrowing down the issues of contention and where there is common ground and where there isn't, and understanding that better, I think. So inspectors' questions are directed towards that.
Yeah, well, that sounds really helpful actually, and that means as well that groups can focus on getting their sort of more knowledgeable technical members to represent as many people as possible to use the airtime effectively when they're at examinations. So that's useful to know. Okay, so moving on to how you or whether PINS can influence the planning system. Clearly you're there to judge whether a plan is sound or whether an appeal is correct or not, but do you, as inspectors, collate trends that you observe at appeals and local plan examinations, and if there are repeated messages that you're hearing either from developers or from community groups or local authorities, do you collate those and pass those back to government? And are you able to try and influence the system where you think things might be broken and say so? And it might be, for example, that I don't know whether you feel the playing field needs to be levelled, and whether you feel, as many community groups do, that the system's not fair because we have to do all our reading in our spare time, all our hearing statements in our spare time, and then you've got rows of experts sitting opposite you at hearing who do that. They've been doing it for years as their career. They've got all the knowledge. So can community knowledge be given greater status than professionals? Because although we might not have the planning knowledge, we know everything about our area. Can PINS help to make the process at examination or at appeal easier for community groups? Because it can be very nerve-wracking. People are thinking, crikey, we've never been to one before. We're up against all these experts. There's an intimidating inspector. So yeah, how can that be helped? And then a little detailed question: why aren't session recordings kept after a hearing? So yeah, how can you influence the planning system? Or maybe you can't.
Okay, so a couple of things there, Rosie, and I think I'd like to start by saying that in terms of weight, whether professionally presented evidence compared to community local knowledge evidence carries more weight, then no, an inspector wants to hear from everyone, and it doesn't mean that it's because it's been put by those that are used to engaging in the system, it's got more weight in it. That's not the case. You know, we're there to understand, as I say, what the issues are, try and narrow those down and direct our questions accordingly. So it's not about attributing more weight to, you know, professionally presented, evidence compared to other. That's not the case at all. We will ask. I think in terms of trends and influence in the system, okay, so you know, I must say first and foremost, as inspectors, our role is to implement government policy through government policy, so MPPF, PBG. You know, we are there to, you know, to implement that through the course of an appeal, or whether it's examining a local plan, etc. We're there to do that. We're not there to develop policy. That's not our role. Two things there. I mean, councils can develop policy, of course, and local plan examinations come to us, and then we determine whether we feel that their policies and their plan will do what they say they're going to do, and that they are sound. Other than that, really, you know, when we get to an appeal situation, it's a very binary role that we have. It's a sort of a yes or no, really. What we can do, though, and I think it really is important to do, is to understand, and you talk about trends and other things, but I think what we do, we need feedback from our inspectors, so that if a government policy or a government objective is you know, not being realised because there is some impediment to policy, then of course, you know, when there's consultation on policy updates, we get an opportunity to feed that back. But that's as far as it goes. You know, we are very much about implementing policy as it is, not making or influencing policy in any way. The only thing we can do is perhaps feedback if a government objective is not being achieved or in the way envisaged, because there is there's an issue with the guidance or the policy itself, perhaps. But that's as far as our role goes in that. We're a government agency, yes, but we're not developers of policy. We're implementers of it, you know, narrowly through the appeal system and through our local plan examination process mainly. Okay.
Which actually, it reminds me, there was a slight question I think we didn't have time to do around the consistency of decision making. Given that you've got all these individual inspectors out on their own, how do you ensure consistency?
So the main way that we look to do that is through our training and our ongoing training as well, so that we're looking to make sure that, you know, our decisions are consistent. Now, you know, if there are discussions or complaints that they're not, that we will look into it. Of course, we will look at, you know, whether there is consistency, say, between different inspectors' decisions, for example, or other things. We will look into that. But it's, again, you know, you have to bear in mind on the face of it, something may look like it's completely inconsistent, but it might be that the evidence presented to you know, each particular inspector was different, you know, or the policy context was different. There might be a change of local plan policy in the interim, or whatever. There's a number of factors actually that might influence that something might seem inconsistent and isn't. But of course, we will clearly look into it, and if there is an issue, there's a complaint process that we would look at, as well as judicial review process as well. So we are alive to that.
Yes, yeah, very, very alive to it, I'm sure. Yeah, and yes, of course, it's that phrase, isn't it? The evidence in front of me. So I suppose that's what you're saying about all the variables, isn't it? Each case is unique.
We can't dig in either. It's worth my while saying, Rosie, that, you know, inspectors can't go digging and looking for their own evidence either. You know, it's clearly really important for all, you know, concerned to bring the evidence to the inspector. They can't go running off looking and digging up for their own evidence either. They have to go on what they have before them. I wanted to touch on recordings as well. So we don't record, you know, events. Events are usually hosted by local planning authorities. They may wish to record sessions, and all we do as inspectors is make sure that you know, everybody participating is comfortable and happy with that. We would only really object to it if there were a lot of objections and we felt it was going to be disruptive to the proceedings. That's the only basis upon which we would ever object to a recording being made.
Okay.
So local authorities, sometimes they do record it, sometimes they don't. I think sometimes it depends on the nature of it. What we found through doing virtual events now and running more of those through the pandemic and seeing more of that, is that we've found it really helpful. And we're working with local planning authorities to say that when there is a large event, when I say large, there's a lot of people that want to observe proceedings, not necessarily participate, but observe. It can be really helpful if we can ask the council to live stream those, because that enables an awful lot more people to, if not actively participate and have a say, at least they can keep a close eye on what's happening and observe proceedings. And what we found, we've done some research with the RTPI on this, and what we found that it's really opened up our events, made them much more accessible and inclusive than we ever would have imagined possible. So for example, I'll give you some statistics. The first local plan examination that we ran virtually through the pandemic was the South Oxfordshire local plan, and we had over 14,000 hits to the council's website observing the hearings of that. Now, we would have never have got that in a physical environment. We wouldn't have got 14,000 people turning up to council offices listening to that. So it just goes to show. The Holocaust Memorial Inquiry, which was a very large, contentious and high profile event that we ran in October 2021, was again, October 2020, was again a very high profile. We had former prime ministers turning up, the Archbishop, but we had over 24,000 hits to the live stream on YouTube for that as well, from all over the world. So we would never again have managed to tap into that audience, had that run in just purely in a physical room. So what we're trying to work towards is where something has a large community impact or something of a wider impact, and lots of people would at least want to observe proceedings, then we're looking to try and encourage local authorities to live stream where that might be appropriate.
Yeah, I mean, that's amazing, isn't it? I think it should be obligatory personally. It's good because I thought I was slightly odd in that I enjoy listening to these things, and I found it amazing since the pandemic how easy it is to go, and you can dip in and out. You don't have to listen to the whole thing, but to find that 14,000 people were listening to the South Oxfordshire one, that's extraordinary, actually. So and it would be useful to have them recorded afterwards, because there are often things you want to sort of play back and check whether you heard them correctly. But that's obviously.
If they are on YouTube, then of course they are recorded. I don't know how long they keep them. There might be a shelf life, but they are recorded and people then can go back and look at them, and that's really useful. I agree. And I think it also opens it up to different demographics as well, because we very rarely get young people involved in a local plan examination debate, for example, and very rarely in an inquiry too. That's not always the case. You do have young people, but those with caring, education, responsibilities, having to take a day off to participate, as you say, as a community group, that can be difficult. It's a call on your time. Just to open it up to other people to engage more widely and be more representative, I think that it's got to be a good thing.
No, I agree. I think it's very positive, actually. So yeah, it definitely makes it more accessible. Okay, now we're getting on to your favourite bit, which is including the tilted balance. So we've got a few technical questions just at the end, not too many, but first one is obviously, please could you explain the tilted balance? And I think you said you might need a day for that normally, but we're going to give you about 2 minutes. So and then slightly similar, but is it a lottery as to how much emphasis an inspector places on the tilted balance and shortfall in the 5-year land supply? I think you've kind of answered that already. It depends on the evidence in front of you, but then you've got, so this is an interesting one, how do inspectors balance conflicts between planning policy and then the wider general legislation such as climate change, net zero, the Environment Act? So you're kind of potentially being pulled in two directions. You might have presumption in favour of development and you might have presumption away from development. So it's quite a juggling act for you. And then how much more weight is going to be given to biodiversity in the light of the Environment Act? And then there's a quite contentious popular one here is, do you take developer funded reports as gospel? Because we have all sat, all of us have seen developer or consultants reports which are sketchy with the truth, omitting things, creative. And we're sitting there in horror thinking, look, it's a professional that's put this forward. So will they just be believed? So that's an interesting one for you to talk around. So over to you.
Yeah, thanks, Rosie. So yeah, I mean, our training on tilted balance runs into days sometimes, but it's very difficult, I talked about engaging and getting people involved in the process, but it's not easy to sell you know, the tilted balance to people, and in a way that, you know, you can readily understand. You know, as inspectors, we do really appreciate that, how complicated that can be and how difficult that can be, and that doesn't help with us, you know, trying to engage people in the process, of course. But I mean, essentially, it's a way for which we have to look at. Tilted balance has to be engaged, and there are certain criteria set out in the National Planning Policy Framework, which, you know, I don't need to rehearse, but I think that is set out there. If, you know, have a look at that in you know, paragraph 11 of the NPPF, and see what does weigh in the favour. But I think all I can say for local authorities, it is really important for them to get you know, a local plan, a development plan in place, and to show an evidence that they've got a 5-year housing land supply. Clearly, you know, that's for the likes of DLUHC to emphasise, and I know they're doing that. I know that they are emphasising the importance for local authorities to get in place their development plans and a 5-year housing land supply in place, because, you know, as we know, if they don't and the tilted balance is invoked, then it's a matter of weighing up, you know, all those considerations. But the fact that there isn't a 5-year housing land supply is a consideration that has to be weighed in the balance. So, you know, if local authorities do have a 5-year housing land supply, then clearly they are in a much better position, you know, in respect of being able to resist any development on for housing where they, for whatever reason, don't think should proceed. Clearly, you know, that's clearly obvious. So there's a lot on that, and perhaps that could be a session for another day, because it is quite complicated. But it's not a lottery. I don't think I wouldn't call it a lottery, definitely not. But of course, inspectors have to go on the evidence before them, and there are certain things that, you know, if you imagine a weighing scales with a tilted balance, there are certain things that will weigh in favour of the development. Say if the local authority can't show a 5-year housing land supply, that'll weigh in favour. But there's other things that may weigh against that, because there might be unacceptable traffic impacts or environmental impacts, or it might character and appearance of the area, or it's outside a settlement. You know, so constantly there's things in this bucket, there's things in that bucket, and it's the inspector's job to you know, balance those and you know, thoroughly understand, you know, what weighs in the balance with those as well. Okay. So I think that's about as far as I can go in 2 minutes on that. But it's not a lottery. It's about balancing these competing factors, I think. On the Climate Change Net Zero Environmental Act, so, you know, how do inspectors balance conflict between planning policy and wider general legislation? So, you know, clearly there's really a general layer of different legislation. So of course you've got national policy statements, which are particularly important when you come to NSIP work, and then of course you've got the planning policy, which is National Planning Policy Framework, and then you've got local policies at the local level. Well, you know, in terms of climate change and other things, then there is a judgment whereby the judges said that clearly that, you know, anything that relates to the wider climate change agenda is there. It's an objective of you know, the wider government, and it's not at a decision-making level that's factored down into NPPF and then into local planning policies. So that's the sort of, if you like, the layered approach. So, you know, obviously local authorities will have their own local plans. There's the NPPF. So, you know, the inspector will determine a planning application, if it's that, based on the, you know, the policies in the NPPF and any extant local plan policies that are appropriate as well. So I think that's where that level of that level of balancing is, and that level of detail is in as well. And it's similar to biodiversity in light of the Environment Act. Well, the Environment Act, and then you've got the NPPF and any sort of PPGs that come down through that as well. And you know, again, the inspector will actually consider an appeal, if it's an appeal, against, you know, a proposal against the policies in the NPPF, PPG, and any relevant local plan policies as well. So it's, you know, it's not more weight or less weight. It's just weight and considerations in the light of the policy guidance and local policy guidance that there is. So it's not, you know, more or less. It's just, you know, within that context. Developer funded reports as gospel. Well, no. I mean, obviously, reports that are presented to us It's important that we know if it's a technical report. For example, you could have a very technical report on noise if it was, say, a wind farm or some such thing, or viability. Now, clearly, we would wish that report, if it's very technical, to be prepared and presented by experts in the field. You know, absolutely, we would. And often you'll have one technical report by, say, the appellant and another technical report by the authority. Sometimes you have two opposing, and usually, you know, equally they're done by experts in the field. So, you know, there is certainly consideration would be given to experts in those particular technical fields. You know, clearly that's very important to us if they are experts in that. But as a matter of you know, per se, it's not that we will you know, favour or give more weight or you know, consider them as gospel if they are developer funded or if they're local planning authority funded. It just depends on you know, what the context is and what the level of detail is within that. And either way, an inspector will question the contents of it, and so will the opposing party, and so may other parties like yourselves, for example. You know, if you notice something that doesn't seem right in the technical report, or doesn't seem to, you know, marry up, or isn't factually correct, or you question, then of course you can do so through your representations or at the event. So that's not closed off to others to comment on technical reports that are submitted as part of an inquiry either, or local plan examination.
Okay, excellent. So as with all of it, put your evidence forward, quote all the relevant policy, and stick to facts, basically, it sounds like.
Yeah, and if you can do it early or in time, that's very helpful, because it's very difficult when, you know, we're running a long local plan examination or an inquiry. You know, if evidence of that nature comes in late, it's always good to have that up front and early on, so that the inspector can ask questions around it. If there are two technical reports, and community groups or others have a question on it or want to make representations, it's much easier to deal with that earlier on, so the inspector can ask questions on it, you know, with the knowledge of the, you know, those representations, rather than trying to do that late in the day, because that might, you know, necessitate an adjournment to go off and consider that, and the parties to have a chance to respond to it and other things, and that can lead to delays, as you may realise.
Yeah, no, I'm sure actually it's probably just as annoying for an inspector as it is for a community group, when suddenly you get a 500-page document submitted late and you've got to read it before the next day, something like that. It's probably just as hard for you to get through. Okay, that was really, really interesting. Thank you. So are you happy we go over to questions now?
Yes, certainly. Okay,
excellent. Right, I'm going to stop sharing screen. Marge, can I hand over to you to manage whatever questions you've got in the chat?
I'm actually going to suggest that we hand over to Caroline, because I think Caroline has done a lot of ticking on where we've got questions. So Caroline, I think you're probably best to do this.
Yes, and first of all, apologies to people who questions I've missed, and also I'm going to omit any mention of what special plan or specific case it might be. So they'll be done in sort of anonymously. So there was a question about a local authority has summarised the representations from the consultation stage, but the community group felt that the summaries mischaracterised some of their arguments and omitted others. How much influence do the summaries have with the inspector, and how does the community group raise their concerns with the inspector or in any other way?
Yeah, thanks, Caroline. Can I just ask, I might have missed the start of that. Was that at a local plan examination stage where there were summaries by the council?
Yes, well, it's I think it's actually a spatial plan, but yes, it would be like a local plan, yes.
Okay, yeah, thank you. So I'm used to seeing those. Yes, the council usually as part of their submissions, when they submit all the evidence for examination at a local plan, we ask them to do this. We ask them to summarise some of the key you know, consultation responses. And in fairness to them, there might be thousands and thousands, and so they may be, you know, trying to get through them and summarising them very lightly. We wouldn't want them in doing that to be misrepresentative, though. So I think if anybody felt that their representations had been summarised incorrectly, then they should say so early on. And I would suggest that you know, ideally that would be done before the examination starts, because there's always a session in the examination where the inspector will put a time aside to discuss early on in the examination. Usually I used to run it this way early on, discuss you know, whether the council is engaged properly and done that, you know, proper. We talked about Regulation 19 early on, whether it's done its proper Regulation 19 consultation, and that means, you know, all the correct advertisements, all the correct community engagement, and I usually run a discrete session on that alone, where I can ask everyone for their views on whether that's been done correctly. And I think that would be the time to do it. But ideally, it would be better to do that before the event, so that either the council were aware of it and could perhaps change that report before it gets to the inspector and make it more representative, so you agree to it. Or if that wasn't the case, then at least get something like an addendum to the inspector to consider that alongside the council's report. And the earlier on that's done, the better the inspector can consider it then and deal with it and get to it very quickly at that session that they hold on the community engagement exercise, and whether that's sufficient.
Could I just ask a supplementary to that, Caroline? So who do the authorities, sorry, the community groups contact for that, Rebecca? Would they go through the programme officers or directly to the inspector?
Well, they'd never get directly to the inspector. If they're sending anything to the inspector, it would always go through the programme officer, so that's the right route for it. But if that report is done and you have sight of it on the examination website and the examination hasn't started, I would suggest, you know, even before a programme officer has been appointed, if they haven't, go back to the council and say, look, we feel that our representations have not been summarised correctly. Could you know, correct it or do an addendum or something? As early as possible is helpful. If that's not possible, then definitely when the programme officer is appointed, and raise it then, I think.
Right, another one. This is about an appeal, obviously. Having had a planning application refused by the local planning authority, the applicant then appealed, whereupon the appeal was upheld by the inspector. What recourse or action is, if any, is available for a local group who oppose the application? Are they right in thinking an appeal to the High Court only on legal grounds is the only thing to do at this stage?
Yeah, so that's right, Caroline. If there is, if a decision's been issued by an inspector, the only recourse that anybody has is to sort of challenge it through judicial review, and that's the only way of getting that quashed or changed. Of course, if you feel that there's an error, you know, we have our complaints procedure, but that's not going to change the decision. The only way of changing a decision is through the judicial review process.
Thank you. A question going back to local plans, actually it could be about applications as well. And you partly answered it about how you access specialist information that might be outside your own area of expertise. But the question actually is, can members of the public also access inspectors for in-depth information and expertise?
And yes, sadly not. Clearly, we're overstretched with the work that we have on appeals and everything that we do. But you know, I digress. But really, our inspectors are independent. We're appointed, you know, through government to deal with appeals and other things. So there's not really easy access to inspectors, and the reason for that is you know, not just one of resources and our remit, which is a clear consideration, but also the fact of this independence that inspectors, you know, we are sort of quasi-judicial responsibilities that we have. So all our inspectors are completely independent, impartial, and our Frank's principles are to be, you know, fair and open and transparent in all things. So there's never an opportunity to have, you know, one-on-one dialogue with inspector, not during the course of an event, or really, you know, very little opportunity other than that, because, you know, everything that has to be said publicly, so that there's no you know, misunderstanding that an inspector's having a private dialogue with one party or another. And that's really, really important for our principles and values, that we, you know, everything we do upholds those, you know, those values of fairness, transparency and openness.
Thank you. Actually, there's several questions about petitions. Firstly, would you recommend backing up objections with a petition? What's the relative weight of a petition versus objections sent in individually? And then there was another one about how do you what best mechanism for a petition would be used, and could you know, at what point should it be used?
Yeah, so yeah, I'm not going to in any way suggest that petitions shouldn't be used. If groups want to gather signatures for a petition, that's absolutely fine, and that's commonplace for us as inspectors to deal with those. I think what we find more helpful is that you know, if rather than there being a number of thousand different, you know, ways of saying essentially the same thing, it just gets easier for us to, you know, deal with the nub of the issues, like I said earlier, narrowing those by understanding what the objections are. And if those objections are backed up by a petition of thousands, absolutely say so. You know, that's fine. But we don't necessarily need 2,000 ways to do it. It's sort of, it also dissipates your efforts as well, I think, because that sort of, you know, an inquiry will only run for so long, and an inspector can only hear for so many. So I think if you focus your points, then you know, and if you back that up with a number of signatures, then that's absolutely fine. But I think if you focus the points, then that's really helpful to narrow the issues. And just because there's one person saying it doesn't mean the inspector will give less weight to it, particularly if they know that point is also shared by a number of others who've signed that petition. So that's helpful.
Thank you. Actually, there was a sort of supplementary question, which was, if a group is purporting to represent the opinions of several hundred or even several thousand people, is it enough to just say we are representative of these people because they've done? They need some sort of documentary evidence of all those people supporting the same case.
Yeah, and I think that's where petitions are useful, because then you have, you know, you have the evidence to say that we are speaking not just on behalf of, you know, a neighbourhood, that we've got, you know, we've got signatures from X amount of people in the community who support this view, and that's where it's clearly helpful to have that evidence. Thank you.
A question about appearing at an examination, and in fact I know this person is about to appear at an examination next Tuesday, so it's very appropriate. If he has submitted a written statement but has also asked to appear at the hearings, does the oral representation have to closely follow the representation, or can he supplement it during the hearing sessions?
It is difficult if you know, the inspector's read the written representations and somebody wants to put that across, you know, orally, and that's fine. They have the right to be heard. I think the strange difficult is if they're going, they say in the representations, then it is in an interest to the fairness of all parties, then that can be difficult, because then, you know, the other side might want to ask supplementary and say, well, you didn't say that in your representations and you're going off. So it's always better to keep, you know, to make sure you get everything into your representation, and stick with that. That's really important. I mean, it's okay to augment it, or, you know, that's not a problem. But if you're going in another direction or adding something new in, then that's when an issue of fairness can arise, and it can be difficult. So fine to augment a point or back it up with evidence if the point is made, but not so helpful to sort of go off into another direction. That's, you know, clearly the inspector will stop that for in the interest of fairness of everyone, and potentially derailing the whole event.
Thank you, Rebecca. And then one about a deadline for written representations has passed. This is for an appeal, but the applicant keeps submitting documentation countering the written representation submitted by the local planning authority. Will they still be taken into account? It doesn't seem fair that they can continue to add evidence after the deadline has passed.
Well, I think it depends on what it is, because obviously deadlines are there to be upheld, and in the interest of fairness, we wouldn't let any party go over a deadline, particularly if there's something coming in and then something rebutting that, etc. Then that's not helpful. We want to keep to a deadline for everyone's sake and the smooth running of an event as well. So yeah, deadlines are there to be adhered to. It might be that it's a statement of case, and there's a statement of case, and each party gets the opportunity to present that. But no, in the interest of the fair running, we wouldn't want representations to keep continuing beyond a deadline, because then that can derail an event as well. And in the interest of the efficient running of it and fairness to all parties, it's important to keep to deadlines. Now, that doesn't mean that things won't come in during the course of an event, and that happens. It's always a difficulty, but it always happens during the course of an event. But the inspector's role then will be to make sure that if they are going to accept it, that everyone has a chance to comment and there's time to do that, because it might mean an adjournment of the event. But we'd like, where possible, to make sure that deadlines are adhered to, and we have everything we can before we open on that first day. But we do realise that there are some situations where things do come in late, and we'll do our best to consider them, as long as everyone has a chance to consider them and have their say in them as well.
Thank you. There were several questions, and you touched on it before in your talk, about areas where there appeared to be different parts of government policy in conflict with one another. And how do you respond to that conflict? What outweighs, or what trumps what? And then a sort of second question is, would a legal duty to consider climate change, I presume the net zero, make your life easier or perhaps harder?
That's a difficult, but both are difficult to comment on. I think in the latter, we just have to, we're not the developers of policy. We are there to ensure that we operate our events, whether it's deciding an appeal or deciding on the soundness of a plan, or examination into a national infrastructure project. We do that within the context of the policy that we have. Now, obviously, if there are things that have been flagged up to us as inspectors that it's not having the intended outcome in terms of achieving government objectives as it was written, we can pass that up, but really we don't do any more than run our events within the context of the development plan and the relevant local plan. So that is important that we do that. So yeah, we will deal with it how we deal with it, but it's for the government really to be the ones who develop policy. We have to run our events in the context of it.
Thank you. Marge, have you picked up any more? Sorry, I've been missing the last few as I've been reading them out.
Sorry, was on mute there. Yes, there are several more that have been added since then.
It might be that I have to come back, because I'm sorry, I haven't got very long now. I had an hour for this, so I did say to Rosie, given the number of questions, it might be that I come back at some stage if you'll have me, and we focus on other areas that you might want me to help with if I can.
That's
Thank
super.
you. Yeah, we'd love that. What we'll maybe do, we'll go through the questions and see if we can group the ones that you haven't been able to answer. And then I know I sent you about 10 pages of questions as well at the end of the presentation. So that'd be fabulous if you're happy to come back again. That'd be really good. Thank you. So in which case I will wrap up. Thank you very, very much for coming. It was really interesting and I found that incredibly useful. And I wish I'd had this when I went to my first examination in public 4 or 5 years ago. It would have been really good. So massively appreciate you coming. Thank you.
Thank you, and thank you for having me, and I hope to see you all again soon.
Thank you.
And okay, just to let everybody know, because there have been some questions about this, we'll put the recording on our YouTube channel, so so you will be able to access this later. Okay.
All right, thank you, everybody. Goodbye.
Thank you,
Rebecca.
everyone.
Goodbye.
Thanks, everyone.
Bye-bye.
Thank you.